Okay. In 1907, the American Bar Association held its annual meeting in August in Portland, Maine. The ABA meetings at that time, like today, were a mixture of sort of general meetings for all the membership, but also specialized meetings of the individual sections. And actually the first section, or subsection really, of the American Bar Association was the section on legal education and admission to the bar. And this was the section that mixed both lawyers and law professors, and it every year had its own program at the ABA meeting. And in 1907, there were two speakers for the ABA section on legal education program. One was the current chair, a man named Roscoe Pound, who was then dean of the Nebraska Law School, although at that point he actually had already accepted a faculty position at Northwestern. And of course he was at Northwestern only a year or two before going to Harvard Law School, where he became later the dean and one of the most famous legal scholars and legal educators in American history. But Pound was giving the presidential address, and the featured address was given by a man named William Reynolds Vance, who was at that time the dean of what was called the Columbian Law School in Washington, D.C., but it's the law school that we today think of or know as the George Washington University Law School. Curiously, Pound's presidential address was entitled "The Need for a Sociological Jurisprudence." It turns out that that was one of the most important short articles or addresses in the history of American jurisprudence. The other talk by Vance was entitled "Legal Education in the South." One of the amusing things about that meeting, even though Pound gave this historic address that people are still citing 100 years later, in the question and answer period that followed, every single question is for Vance. And no one thought that Pound had said anything worth following up, apparently. Well, but what I want to focus on, of course, is Vance's talk. Now, Vance, as I said, was the dean at what we now call George Washington, but he had earlier been a faculty member at Washington and Lee. He was a native Kentuckian, but he had come to Washington and Lee both to study to study as an undergraduate, had done splendidly well, and had actually been hired as an instructor in English after graduating. And while teaching in the English department, he had enrolled in the law department as well, had done spectacularly well in the law school, and once he finished his law degree, he had been immediately hired to the faculty. So what I want to look at today is sort of the career of Vance, but also the sort of history of Washington and Lee, and as a partial explanation of why it was that Vance had left Washington and Lee. Now, the topic of his address, as I said, was legal education in the South. And Vance announced at the outset that he was really here to defend legal education in the South. Now, he acknowledged that at that time, most progressive legal educators viewed the South as a real intellectual and educational backwater. That there was a movement afoot in American legal education to raise standards and to make legal education more professional and more academic, and that movement by and large was being ignored in the South. In 1900, the law schools, the Association of American Law Schools was created as a specialized professional organization for law schools themselves. Now, in its early history, the AALS, as it's called, met in conjunction with the ABA, and in fact the 1907 AALS meeting was held in Portland, I think the day following the section meeting where Vance gave this particular talk. There were only two Southern schools in the Association of American Law Schools, and given the two principal features on which the AALS insisted, first that the law course be 3 years long, and that all law students have a high school education or the equivalent before beginning law school, virtually eliminated almost every Southern law school. In fact, there were only, of the 30-some law schools in the South, only 4 met those criteria. And of course, Washington Lee and the University of Virginia and the University of Richmond were not among the four. Graves admits that the South is behind the times, Southern law schools are behind the times, but he says it's not really their fault. The South was economically ravaged by the Civil War. Circumstances have been such that it's never really had the opportunity to recover. Southerners are poor. Very few Southerners can afford to take 3 years to study for the profession. Moreover, because Southern bar admission standards are low, no Southern state requires a lawyer to go to law school. No Southern state requires a lawyer to have any particular prior education before being admitted to the bar. In most Southern states, anyone who wants to take the bar exam can just show up and take it. And in a world like that, it's unrealistic to expect law schools to be able to demand higher standards for their students. Plus Vance notes at least there's one positive thing, that almost all Southern law schools offer instruction during the daytime. The other great controversy in the early 20th century American legal education was the legitimacy of the urban night law schools, which had sprung up in most major cities beginning in the late 1880s, and by the time Vance gave his talk in 1907, a majority of American law students were at that time were attending urban night law schools, which offered essentially evening-only instruction. And Vance points out, at least in the South, you don't have night law schools. But then at the very end of his talk, I think Vance reveals what it was that he was really most concerned about. And so the final portion of his talk is really a kind of attack on Washington and Lee and the University of Virginia. That there are reasons why most Southern law schools can't be in the forefront of the movement to raise standards in American legal education, but there's no excuse for Washington and Lee or UVA for being so backward. They have the tradition, they have the institutional strength, and at least they have a history of being leading institutions of legal education, and they've just simply refused to assume the role that would be appropriate, according to Vance, to the great embarrassment of all Virginians who know that the state can do better. So it seems like what Vance was really doing in this talk was offering an explanation, at least I argue, for why he had left Washington and Lee a few years earlier. So I want to go back now and talk about the history of Washington and Lee in the years after the post-Civil War period. Because I think this is a story not just about Washington and Lee, but about legal education in the whole American South. Now, I'm sure much of this story will be familiar with you. Many of the names that I mentioned, or almost all the names that I mentioned, are people whose portraits hang in these hallways. I'm sure probably most of you know that the Washington and Lee Law School really began in the pre-Civil War period as an independent institution called the Lexington Law School, operated by Judge Brockenroe, a prominent Lexingtonian who was also a federal court judge for Western Virginia, and then after secession, a federal court judge within the Confederacy. Do you know where the Palms restaurant is? That building, as I understand it, is still the same structure that was there in the 1850s, and that's where Brockenroe conducted his law classes. Now, he closed his law school in 1861 when the Civil War broke out, but when it ended, he decided to reopen it. Again, not as part of Washington College, but just simply as the old Lexington Law School now reopened. But Brockenroe was very closely connected to Washington College. He was on the Board of Trustees. He was chosen as the college's first rector. So he was very much involved with what was going on at the college. There were also other members of the trustees who thought it might be a good idea for Washington and Lee to have a law department, for Washington College to have a law department, and President Robert E. Lee apparently was sympathetic to the idea. So it initially began as an informal affiliation between the Lexington Law School and Washington College, but by 1871 the old Lexington Law School had been incorporated into the structure of what was now, for the first time, known as Washington and Lee. There were great hopes in 1871 that the law school would attract large number of students and bring attention to the college. A second professor was retained that year to assist Brockenbrough, and that was John Randolph Tucker. Now, Tucker was a member of one of the most distinguished legal families in the United States. His grandfather, St. George Tucker, had been one of the founding fathers, the author of the first American edition, or at least the most important American edition of Blackstone, himself a legal educator and a judge. His father, Henry St. George Tucker, this is the first Henry St. George Tucker, had been a professor at one of the, I think the second professor of law at the University of Virginia, and had been the head of the Virginia Supreme Court of Appeals. And he himself had already had a distinguished career, serving as Attorney General of Virginia and then as Attorney General of Confederate Virginia, although he lost his job after Appomattox. And in fact, had gone to work for the C&O Railroad and was working as one of the chief counsel in the Baltimore office. But given the opportunity to come to Washington and Lee as a professor of law, he gladly accepted the opportunity. Being a smart railroad lawyer, he negotiated a kind of special deal for himself that later worked to his advantage. But the idea was that Brockenbrough and Tucker would divide the law course and offer instruction in Lexington. Of course, there is an ever-present factor, certainly in the 19th century, of course, for the law department of Washington and Lee, is the presence of the University of Virginia Law Department, just 70 or so miles away. And the University of Virginia has 2 law professors with a divided course, and so Washington and Lee now is structured along the same model. Well, the idea that large numbers of students would immediately flock to Lexington proved to be a little overly optimistic. And while the enrollment of the Washington Lee Law Department was greater than it had been in Brockenbrough's private school, it remained quite low, really just in the neighborhood of 20-some students enrolled at any particular time. And too much, and really not attracting enough students to pay the salaries of Brockenbrough and Tucker. So the decision was made to cut back to 1 professor, or at least 1 distinguished professor, and in part because of the nature of Tucker's contract, but I think also in part because there was a kind of growing notion that Brockenbrough was something of an old windbag and not a particularly good teacher or lecturer. The decision was made to let Judge Brockenbrough go. Now, of course, he felt quite bitter about this. Actually believed that it had to do with these internecine Presbyterian-oriented politics that were a major factor in the history of Washington and Lee in the 19th century. But he also felt like it was fundamentally unfair that his law school had sort of been taken away from him. But nevertheless, the ties were severed. Now, there was still at least the view that you needed a second law teacher. And in place of Brockenbrough, Charles Graves. Now, there's interesting parallels between Graves and Vance, although Graves is much earlier. Graves himself had been an undergraduate at Washington and Lee, and had himself also studied law while teaching as an instructor in English at the college. And in fact, in an era where most Washington and Lee students took the entire law course in a single year, this was done at the University of Virginia as well. The lectures were scheduled in such a way. There was a junior course and a senior course, but the lectures were scheduled in such a way that you could attend all 4 courses, Brockenbrough's junior, Tucker's junior, Brockenbrough's senior, Tucker's senior, all in a single year if you wanted to. And a significant majority of Washington and Lee's law students in the post-Civil War period did take the whole course in a single year. Graves, I think, because he was entitled to take 1 course at no charge every year, actually took 4 years to complete the law course, and of course did splendidly well and was just appointed to the law faculty even though he had never practiced law once Brockenbrough was discharged, albeit at a much lower salary. Graves was paid, of course, a much lower salary. So the law school didn't really change. It was still structured as nominally a 2-year course, but a 2-year course that most people took in 1 year, with the course divided between Tucker and now Charles Graves. Nevertheless, enrollments didn't improve significantly. But even the cost saving of having severed Brockenbrough's, for the times, hefty salary still left the law department in dire straits. And there was growing sentiment that the program should just simply be terminated, although the concern was that would reflect so badly on the institution that the college would suffer if such a course was taken. In a way, what bailed out the law department economically is that John Randolph Tucker decided to run for Congress and was elected to represent the Valley of Virginia in the 1876 elections, where he was a conservative Democrat, and this was an election in which the Democratic Party made something of a comeback throughout the United States. Tucker announces that he's leaving the full-time faculty to enter Congress. So the decision is made then to just go with one law professor, Graves, and to supplement Graves with lectures by distinguished lawyers and judges, one of whom, of course, will be Tucker, who will come back when Congress is not in session and deliver lectures on constitutional law. But there are a group of lawyers and judges, two of the judges on the state Supreme Court, other lawyers, most of whom had some prior Washington and Lee connection, will come in periodically throughout the year and deliver lectures on their specialty. So that will be the law course. If you actually just look at the bulletins, it looks like the faculty goes from 2 professors in 1876 to 7 in 1877, but in reality it goes from 2 paid professors to 1 paid professors. But even that is hardly enough to keep the law school solvent. But it trudges along, at one point I think getting down to 15 or 17 students total enrollment, but it never completely disappears. In Graves, even though he's not attracting large numbers of students, is increasingly respected as a legal scholar and as a teacher. Moreover, even though its enrollment is small, Washington and Lee's law department draws, if not exactly a national student body, at least it draws a regional student body with with a majority of its students coming from outside Virginia, although most of those from the South or border states. So it trudges along. I mean, in some ways, the real problem is the prominence of the University of Virginia, and particularly its longtime head, Professor John Barbie Minor, who was on the Virginia law faculty from 1845 to 1895, and who was a kind of, although he's largely forgotten today, he was in his own time sort of linked with Cooley in Michigan and Langdell at Harvard as one of the great experts on law in the United States. And that's a very tough act for Washington and Lee to compete with. Nevertheless, the circumstances do seem to change, and change very favorably in the middle of the 1890s. For one thing, Minor has gotten so old and so set in his ways, he's slowly eased out at the University of Virginia. Against his will, new faculty members are added, the curriculum is changed against his will. He somewhat facilitates the process by dying a bit unexpectedly. So at least by 1895, John Barbie Minor is no longer on the scene. At the same time, or approximately the same time, John Randolph Tucker decides to retire from Congress after a long, distinguished career. He initially stays in Washington primarily to argue cases before the Supreme Court as an advocate, but he becomes enamored with the idea of returning to Washington and Lee as a full-time faculty member. And the trustees at this point, particularly now aware that Minor has exited the scene, and that he's not quite the drawing card that he had been historically, that this might be an excellent opportunity for the Washington Lee Law Department to expand. So they decide to go ahead and invite Tucker to come back. And so he does, and enrollments start to increase almost immediately. In fact, they increase so significantly that Graves and Tucker are able to convince the trustees that what they really need is a third professor of law, particularly since the University of Virginia has a third professor of law. So they decide, following in the tradition of Graves 20-some years earlier, to hire their most outstanding recent graduate, a young man from West Virginia named John W. Davis, who joins the faculty as a professor specializing in corporation law. It's an interesting choice, although not surprising for people who know the way in which law professors begin their career. Davis had no expertise in corporation law, had never practiced corporation law, but neither Tucker nor Graves particularly wanted to teach corporation law. So Davis became the professor of corporation law. Again, I'm sure as most of you know, Davis ultimately went on to extraordinarily distinguished career as a congressman, a U.S. ambassador to Britain during the First World War, as a Solicitor General, as the founder of the Davis Polk law firm on Wall Street, 1924 Democratic candidate for president, and of course widely recognized in the early part of the 20th century as the premier Supreme Court advocate of his time. So this is, if one just kind of freezes the frame here in 1897, this looks like an extraordinarily impressive faculty of Graves, well established as a law professor, Tucker, a nationally known political and legal figure, and Davis, a young man of enormous promise. And the law school seems to be, again, in terms of increased enrollment and greater visibility, seemingly benefiting. But in 1897 and over the next 6 years, wheels keep coming off the bus. Now, some of these things, of course, are simply unfortunate. John Randolph Tucker died in 1897. And John W. Davis decided that really teaching, it wasn't really the career that he wanted to pursue. So the trio of Tucker, Graves, and Davis are actually only at Washington and Lee for a single year. Tucker dies, Davis decides to go back to West Virginia and resume practice. But at least in the short run, Washington Lee seems to be able to sort of fill those gaps fairly quickly. As it turns out, after Tucker's death, available to take his position is his son Henry St. George Tucker. Now this is the second Henry St. George Tucker. John Randolph Tucker's father and son were both named Henry St. George Tucker. But Henry St. George Tucker had succeeded his father in Congress, and also as a conservative Democrat, although in 1896, Henry St. George Tucker's opposition to free silver was so adamant and intense, and his unwillingness to support William Jennings Bryan, the Democratic presidential nominee, so clear that the Democrats of the Shenandoah Valley refused to renominate him to Congress. Instead nominated a man named Hal Flood, who goes on to a very prominent Virginia political career in his sense. So Tucker isn't really defeated, but he's out of Congress because his own party will no longer nominate him. Tucker is Henry St. George Tucker is a graduate of Washington and Lee, both the college and the law school. He's a longtime president of the Alumni Association. He's a member of the Board of Trustees. So he's obviously resides in Lexington. So it's both an obvious choice and quite enthusiastic about replacing his father on the Washington and Lee faculty. Davis is replaced by Vance, having tried a brilliant young graduate one time, or I guess you say twice, with Graves 20 years earlier than Davis. They then turned to their most recent brilliant young graduate, William Reynolds Vance. And so a kind of new faculty containing Graves, Vance, and Henry St. George Tucker emerges. And there seems to be no real loss at the law school, at least in terms of the attractiveness of the school. But then things do start to happen that clearly work to the school's detriment. Most crushing of all is that in 1899, Graves announces that he's leaving Washington and Lee to accept a professorship of law at the University of Virginia, a kind of doubly stinging blow. Moreover, Graves's deal at Washington and Lee is that he gets paid a salary of $2,800, which then was a considerable salary, and he's given a free house. The offer in Charlottesville is $3,000 and a free pavilion on the lawn, but so not even an extraordinarily better offer, but nevertheless, he departs. Graves is replaced, at least initially, by a man named William Clark, who's a quite colorful individual, but someone the law school here seems to have intentionally forgotten completely. Some people have run across a case called Clark versus West Publishing Company, which has been dubbed the case of the drunken law professor. It's not funny, I suppose. That Clark was, throughout his career, was plagued by alcoholism. He was, arguably, in 1899, the leading writer of legal textbooks in the United States. He had a special contract with the West Publishing Company, producing, I think, what we would probably today usually refer to as horn books, but writing sort of definitive texts for educational purposes. And he was the leading seller of legal texts of his time, and probably, at least their claims were made, that his works were used in more law schools than the works of any other legal writer. Now, of course, this is really before the case method has become the norm. So most law schools in 1899 are using treatises as their principal implements of instruction. So Clark was actually originally from Winchester, and it's considered a great coup that he's willing to come to Washington and Lee, because he resides in New York City. And it's actually quite interesting that this is the first academic position he's held, although his time here is unhappy, and he's actually fired during the middle of his first term on the faculty for at least what the president viewed as unacceptable alcohol-related incidents, drinking in public, having students come into his office to drink with him, regular absence from class, etc. There's a wonderful set of letters over in the archives where Clark tries to defend himself, but it was to no avail. Clark is replaced by a local lawyer initially, and ultimately replaced by a man named Martin Burks, who was then the reporter for the Virginia Supreme Court, and a very well-established lawyer, but not someone with at least the sort of academic credentials of Clark. Then other bad things happen. President Wilson, not Woodrow Wilson, but Washington and Lee's President Wilson, dies unexpectedly after the turn of the century. And Henry St. George Tucker becomes the acting president and is prominently mentioned as the likely successor to President Wilson, but he's passed over for the presidency. This is an issue of major controversy in the history of Washington and Lee at the time. And Tucker feels like, having been passed over for the presidency, he has no alternative but to resign from the law deanship as well. So he leaves the faculty in 1902. Vance is named the acting dean, and then to replace Tucker. After a year away from legal education, Tucker becomes the dean at George Washington, or Columbian as it was then called, and his first act is to hire Vance to the Washington and Lee faculty. So they're both, Tucker and Vance are gone by 1903. Washington and Lee, of course, replaces them, but the sort of luster is gone, or at least this constellation of the two Tuckers and Graves and Vance and Clark and John W. Davis, all sort of significant people for various reasons in the history of legal education, all at Washington and Lee between 1897 and 1903, but by 1903, all gone. Well, why did they all leave? Was it just sort of bad luck, as it seems like it clearly was in the case of John Randolph Tucker? I think it wasn't just that. I think, obviously, Clark didn't leave for these reasons, but I think certainly for Graves, for Vance, and probably for Henry St. George Tucker as well, it was the reluctance of the Washington and Lee trustees to allow, quote, improvements to be made to the law school that ultimately induced them to look elsewhere. This idea of trying to bring the law school more in line with the leading law schools of the United States, of wanting to do this, of raising the standards of admission. Until late in the first decade of the 20th century, it's much easier to get into the Washington and Lee Law School than it is the college. The college requires the equivalent of a high school education. The law school does not. The college requires essentially 4 years for a degree. The law school is not even willing to require 2. Once John Randolph Tucker dies, Charlie Graves is able to rearrange the curriculum in such a way that it's almost impossible to complete the law course in a single year. But even there, where the rest of the country, at least the leading law schools, the rest of the country are all committing to 3 years, Washington and Lee is having trouble really requiring its students to go 2 years. The trustees, it appears, although the records are a bit sparse on this, but it appears the trustees are just simply unwilling to let the professors like Graves and Vance and Henry St. George Tucker institute these higher requirements. And why are they doing that? Well, I think this is the Southern problem, right? That of course, they've gone through decades of of borderline enrollment, right? They've gone through the whole period from the 70s to the 90s. The logical move would have been to just simply shut down the law department. Now they're getting students at the end of the century. Well, why are they getting students? Well, one reason they're getting students is because it's a place where you can do the whole law course in 1 year. In the paper, I mentioned a number of people who come from as far away as Oregon to go to Washington Lee in this period because it's a respectable law school where you can do the whole course in 1 year. Even Newton Baker, a later cabinet member, comes to Washington and Lee, largely because of the attraction of the possibility of still doing the law course in 1 year. And particularly after Minor's death, when the sort of reformers gained control of the University of Virginia and raised the law course to 3 years, and started instituting a high school diploma as a prerequisite. Well, that's when Washington and Lee's enrollment really takes off. In fact, it's one of the ironies of having lost all these famous law professors between 1897 and 1903. The real boom in enrollment at the Washington Lee Law School comes after 1903. But I think it's not because of the fame or glory of the instructors who are teaching there. It's because of the attractiveness of going to a law school where you don't actually have to have a high school diploma, although that is actually taken care of in 1908-09. But also going to a law school where you don't have to devote 3 years to the law course, where you can do the whole course in 2 years. So I think what's happens, on the one hand, you have a faculty that wants to, quote, upgrade their institution to bring it in line with the leading institutions of the United States. But you have a group of trustees who realize that by keeping the standards low, they're making the law school particularly attractive and bringing in the one thing that had always been in short supply at the law school, which is lots of law students. So I think that's where the point of contact occurs. That's what ultimately drives away Graves and Vance in particular, and I think also, at least to some extent, Henry St. George Tucker. Now, of course, Washington and Lee didn't remain a backwater institution for very long. By 1920, it decides to join the Association of American Law Schools. So by 1920, it's adopted the 3-year curriculum and the high school diploma requirement. In fact, in 1923, when the ABA begins rating law schools, Washington Lee is one of only 39 schools, I believe that's the number, to receive an A rating during the first ever ABA accreditation exercise. So by the early 1920s, Washington and Lee has completely caught up. So what happened between 1903 and 1920 or 23? And this I'll close. Well, I think what happened more than anything else is that the South changed. Right? The conditions, that had sort of dictated that keeping standards low in the first decade of the 20th century had changed even in the South by the third decade of the 20th century. First of all, of course, just education and high school diplomas become much more common in the South. Right? We forget how relatively recent the phenomenon is, of assuming that almost every competent adult will be a high school graduate. Nationwide, around 1910, it's probably only something like 15% of the adult population hold high school diplomas. So while it seems today almost comical to say, well, we don't think lawyers should have to be high school graduates, to say that in 1900 was, to significantly eliminate a large portion of the pool of potential lawyers. I think also the bar in the South took up the cause of higher standards by the 1920s. Because once states like Virginia began to require 2 years of college study before you can take the bar exam, then of course it's very easy for law schools not just to require high school diplomas, but even to require 2 years of college studies. If you have to have it for the bar anyway, then there's no particular problem with requiring it as a prerequisite for law school admission. So, as I say, by the 1920s, Washington and Lee is clearly on board in part of the national mainstream. But 20 years earlier, I think because of these particular economic and social situations in the South, it wasn't ready to join that mainstream. And I think that really explains what William Reynolds Vance was talking about in 1907. He disagreed with the Washington Lee trustees. They thought that the better case was for higher standards and that Washington and Lee should have bitten the bullet and raised its standards. And when it refused to do so, he left. He did go on to a quite distinguished career. He was later dean at Minnesota and then for many years a professor of insurance and corporation law at Yale Law School. In fact, you walk into the Yale library, there's a big picture of William Reynolds Vance, although I've been told by at least one Yale Law School graduate that he's known as the person about whom nobody has any idea who he is. Okay, well, thank you very much.